Hi, Kai Rosga here. Welcome back to the weekly wrap-up brought to you by Tech Law Decoded. I hope everyone had a nice Thanksgiving weekend. And now as we jump back into the work week, I thought I would provide a new update on the latest in tech and antitrust. This week, I'll focus on how antitrust laws are being used to try to rebalance the relationship between the large online tech platforms and the business users who depend on them. So I'll focus on two ongoing investigations. One, the EU's investigation of Amazon and how it treats third-party vendors on its marketplace. And two, an investigation by the French Competition Authority of Google about how it treats publishers. Just a reminder, this is not legal advice and the views expressed are my own. So starting with Amazon. The EU issued a statement of objections regarding Amazon in its investigation of how that company uses third-party seller data. In particular, it focused on Amazon's dual role as both an operator of a platform as well as a seller on its own platform. And it focuses on the data that Amazon has access to about third-party sellers. For example, sales, revenues, shipping information, things like that. And whether access to that data puts Amazon in a position where it can advantage its own retail sales and sort of result in what the Commission would consider an unfair method of competition against those third-party sellers. This investigation involves what is called an abuse of dominance claim. In the US, this is called monopolization. And it requires essentially proving two things. One, that Amazon is dominant in a market. And two, that it abused that dominance to restrict competition in that market. So when it comes to that first part, proving dominance, the Commission may have some more issues here than it did recently in its investigations of other large tech companies like Google. In part because Amazon's market share is probably not as significant, for example, as Google's was in the general search market. And the Commission will have to deal with arguments concerning, for example, other online sales that Amazon would say have to be included in the definition of the market, as well as brick and mortar sales as well. But the bigger challenge the Commission ultimately will be in that second part of an abusive dominance claim, and that's in proving that there were abusive acts that restricted competition. Here, the Commission's press release on the statement of objections is tellingly vague. It notes, for example, that the data that Amazon has access to could help, quote, calibrate Amazon's retail offers and strategic business decisions to the detriment of the other marketplace sellers. Or, quote, allows Amazon to focus its offers on the best-selling products across product categories and to adjust its offers. And this may signal a sort of weak spot, a legal weak spot in the Commission's case. And this should not be surprising, and the lack of detail at this stage of the case should not be surprising concerning those allegations, because the Commission has to deal with the fact that the antitrust laws, as currently formulated, really focus on consumer-oriented harms. So what that means is, to the extent that third-party sellers are harmed, to the extent that consumers were benefited as a result of that conduct, this could cause a challenge or a problem for the European Commission's theory of liability in the case. Because one can imagine, for example, that the conduct at issue here, or the fact that Amazon does operate as a seller of its own private label products, could benefit consumers. It could result in lower prices, more options, and these sorts of benefits to consumers are going to be strongly considered and weighed ultimately under the antitrust laws. Now, having said that, it may not be as tough of a case for the European Commission as it might be for a U.S. enforcer, because recently European competition law has moved in a direction where unfair competition and harm to competitors can be used as the basis for an antitrust claim, more so than in the U.S. So it's by no means an impossible task, but one worth following, especially if we want to know where the law is headed in the important area of abusive dominance in tech. The concerns raised in the statement of objections track things that were raised in the recent antitrust report by the U.S. House of Representatives Judiciary Committee. There, the report talked about conflicts of interest that Amazon had by operating as a seller and as an operator of a platform. But these are ultimately at the core of the same issues that the Commission seems to be raising in its investigation. So this will be an important investigation, and the ultimate result will probably have a major impact on the direction of antitrust enforcement in tech more broadly against platforms around the world. The next topic I'll cover is an investigation by the French Competition Authority of Google. And here the investigation focuses on Google's use of content that publishers or website operators put out in its search results. In particular, in the Google News feed or newsreel, which shows up and broadcasts little snippets or introductions of articles in response to a user searching for something on the general Google search engine. Now, in 2019, the EU Digital Copyright Directive went into effect, and France, transposing that into a national law, passed new rules that said that online platforms must negotiate in good faith with publishers when, quote, scraping their content, so when using their content. Following that law, Google announced late last year that it would stop using snippets, thumbnails, infographics, other things like that appear next to the link to a publisher's content in a Google search result, unless the publishers agree not to be compensated for that use. In other words, the publishers would have to grant a free license to their content under that new law for anti-scraping. Otherwise, Google would just stop showing those snippets at all and stop showing the publisher's content in its search results. That led to the French Competition Authority opening an investigation, an antitrust investigation against Google. And the preliminary findings were that this was an abuse of dominance. The market that was being abused is described as the market for general search, in which the French Competition Authority concluded that Google had upwards of 90% of search traffic in France. And the abusive conduct at issue was Google's failure to negotiate in good faith in accordance with that French anti-scraping law. In particular, the preliminary findings of the French Competition Authority described that Google had imposed unfair trading conditions on the publishers by refusing to comply with that anti-scraping law and not negotiating in good faith to use the publisher's content. And secondly, that this was an abuse of economic dependence. And this is sort of a uniquely European concept that appears in some national antitrust laws in Europe, which you will not find in places like the US, which is the idea that if a company like Google has a relationship with a publisher and the publisher is economically dependent on Google, that Google could abuse that position of power, that relative position of bargaining power. And here the allegation is that it done so by failing to pay publishers for directing a large chunk of traffic that the publishers were dependent on. As part of its preliminary findings, the Competition Authority imposed interim measures, which are essentially remedies that are put in place pending the result of a full-blown investigation and decision on the merits. And in particular here, the interim measure was to require Google to go ahead and negotiate in good faith with publishers in order to use their content in its search results. That interim measure and that preliminary decision was upheld last month by a court of appeals. And Google has, in the meantime, been engaging in negotiations with publishers in France. It has struck deals with some, and other publishers have issued formal complaints to the National Competition Authority, claiming that these negotiations have not been conducted in good faith. In addition, Google has been taking some other measures, business measures, PR measures, to try to deal with this issue. It announced recently that it has launched the News Showcase, which is a news tab that contains news content from publishers on the internet. And as part of that, is committed to paying out $1 billion to publishers of content and in order to help support the news media landscape, which has been changing recently and has been a difficult one for publishers to survive in. Ultimately, the factual question here in both the negotiations as well as when it comes to determining whether there was an abuse of dominance has to do with whether Google is the one that's benefiting from this sort of arrangement ultimately, or whether the publishers are. And what I mean by that is which way the value is flowing. Google argues that the publishers are receiving the bulk of the value here because Google is directing search traffic, it's directing users to the publishers' websites. On the other hand, the publishers say that Google is the one deriving the bulk of the value here because A, it gets access to data about the publisher's users that it can then use to improve its algorithms and improve its revenues on the ad side of its business. And in addition, that Google benefits more directly through ads that might appear and generate revenue for it, beside the content that's being used that the publisher provides. And so the question here is who's really receiving the value, and that's sort of what's going to drive the results of these good faith negotiations, as well as the views of competition authorities about whether there's conduct that's could be labeled abusive and harmful to these publishers, which are undoubtedly dependent in some way on Google's platform for their users. So that's it for this week. Thank you for tuning in. Have a great week. And in the meantime, if you want to see the latest on developments in tech and antitrust, follow me on Twitter at Kai Rosga, or check out the website techlawdecoded.com. Until next week, take care.